thumbs up.
Yep, there it is.
Great. If you've received a copy of the criminal complaint in your case, can you please give me another? That's a thumbs down. They did not receive a copy of the criminal complaint in this case.
He has received a copy. It's outside his cell. He's in a smock, so he doesn't have it right now. And can you speak into the speaker or the speakers so we can hear better?
I'll speak up. How about that? So they haven't been informed of the charges against them. Is that what you're saying? That Commissioner, can you perhaps relay the charges?
Yeah, absolutely. I think that's reasonable. So count one alleges attempted disarming of a police officer. It's alleged that on Saturday, August 3rd, in the city of Madison, Dane County, Wisconsin, that the defendant attempted to intentionally disarm John Young, a peace officer acting in an official capacity, by taking a dangerous weapon from John Young without consent, which item was being carried by the officer. It's a Class H felony that carries up to a $10,000 fine, 6 years in prison, or both. Counts 2 through 5 all allege that at that same date, time and place, that the defendant had been charged with a felony and released from bail or from custody under Chapter 969, our bail laws, and that the defendant did intentionally fail to comply with a term of bond by committing a new crime. It's a violation also of section or of the criminal code sections that constitute a Class H felony. Similarly, those counts would each carry up to a $10,000 fine, 6 years in prison, or both. So those are the nature of the charges. We should talk about branch assignment. The other open Dane County cases, of which there are 3 felony cases, are assigned to Judge McNamara. There are also multiple cases pending in Jefferson County, but for today's purposes, we need to get this case assigned to Judge McNamara.
Yeah.
I think you said there was some question about public defender eligibility.
That's correct.
Okay.
The paperwork I have here just basically says undetermined.
Got it. So I know that we've discussed this in the past, but you do have the right to a lawyer. I think that there is Attorney Luxay as counsel of record in the other various pending cases. And I think Attorney Luxay was privately retained. Obviously, you'd be free to follow that same process. You'd be free to hire any other lawyer of your own. You're always free to apply at the public defender's office, and you can choose to represent yourself. Those are all options. Do you want Mr. Sheehan to represent you here today at this hearing? If so, please give us a thumbs up.
Your Honor,
That's a thumbs down.
I would like to represent myself in the absence of Amber Luxay.
That's fine. I appreciate that. And I know we've met in the past, and I think you're competent for the purposes of doing that. I no issues with that at all. At any point in the future, if you decide to have Attorney Luxay here or any other lawyer, that's going to be your option too. So that's all fine. Does the state have a position regarding bail in this case?
State is requesting $5,000 cash bail along with standard non-monetary conditions. The reason for cash is, as Your Honor noted, the defendant's open cases. This is his 4th open case in Dane County over just about the past month. Most of these involve disrespect of law enforcement, looping in the Jefferson County cases. We have 23 CF 59 out of Jefferson County that includes throw, discharge, bodily fluid, a public safety worker. We have 24 CF 349 out of Jefferson County that includes vehicle operator, flee elude. In Dane County, I do not have the case right in front of me, but I do know that there was a resisting. There's also a battery or threat to a judge, prosecutor, law enforcement officer in 24 CF 1753. Now another case, disarmed a peace officer, again, all happening within the past few weeks. This is despite having posted substantial cash bail in the past. I can also say that I believe that this last one happened very shortly after his most recent initial appearance. Given the repeated violations of court orders, given the disrespect toward law enforcement, given the fact that significant amounts of cash bail seem to have not deterred this effect, the defendant's exposure continues to grow and grow and grow. The state believes the only option is significant cash.
And Mr. Misener, I'll give you an opportunity to respond.
Yes, Your Honor. And then in this instance, we have to question how much we're going to consider criminalizing mental health. This was a clear suicide attempt. I was taken to Winnebago for 5 days where I was placed in involuntary care under emergency detention by the same law enforcement agency that I allegedly attempted to disarm because they thought I was a danger to myself. I spent 5 days there, again, involuntary care, and I was returned to the Dane County Jail. And as you can see, I'm still in a suicide smock that they refuse to let me out of because they continue to think this was a clear mental health issue. Furthermore, Your Honor, this attempt to disarm a police officer, I was shackled to a hospital bed with both arms restrained and my feet in shackles. The police officer was 5 feet away from me. I waved my hand in his direction and said, "Please shoot me in the head." This was not a legitimate disarming of a peace officer. This was a clear cry for help, which is what exactly it was. I cannot post $10,000 bail, or I would have already done it rather than feeling despondent and suicidal. I have reached my limit. I already posted close to $9,000. I qualify for Badger Care. I do not have large quantities of money in my bank. I posted $9,000. That's it. I am in jail with $10,000. It would be adding insult to mental health injury at this point to just be slapping on more thousands of dollars.
All right, and I do have a legal question actually about count one. It charges attempting to disarm a police officer and describes that as a Class H felony. Disarming is a Class H felony under section 941.21, but I question whether an attempt would have the same penalty provision. Oh, you know what? It does. That's an interesting quirk in the attempt statute. So section 939.32 sub 1 sub CM says whoever attempts to commit a crime under 941.21 is subject to the penalty provided in that section for the completed act. Why they don't build the attempt into the actual substantive crime instead of putting it there, I'm not quite sure, but that's I guess that answers that question. Any response from the state regarding the bail arguments?
No, the state stands on its argument.
All right, I have to tell you, I'm not inclined to follow either the $5,000 cash bail recommendation or the sort of inherent request for something less than that I'm hearing from the defendant. I'm incredibly concerned about the safety of Mr. Misener as well as other police officers or other individuals that might be nearby, just given the totality of the charges in the various cases and what's reflected in this complaint. I guess before I fully form an opinion about that, I'd give each party an opportunity to add anything more.
I have nothing further to add.
And Mr. Misener, obviously, I don't want to put you in a position where you're forced to say something about the allegations themselves, because there's a court reporter here that takes it all down. But I heard your arguments earlier. I would certainly be happy to hear any additional ones that you have regarding bail.
Your Honor, $10,000 is going to retain me in jail just as much as $15,000 is. At this point, again, we're just adding money onto cash bail to add money onto cash bail. I mean, my parents have flat out told me they are done helping. I do not have anyone left in my corner. Again, I did not know about this charge until today. I would have attempted to post bail upon returning from Winnebago if I could do it. There's just no sense in continuing to add thousands of dollars onto my bail.
So I appreciate that argument. I think there's a lot to be said for Mr. Misener's point about the fact that there are some obvious significant mental health components to all of what's alleged in this complaint and in the other complaints. That doesn't really reduce the level of threat or risk. It is the case that the defendant has picked up just an almost astounding number of charges in the fairly recent past. Nearly all of them, if not all of them, involve some form of battery or threat to a law enforcement officer, or a pursuit, or discharging fluids in the direction of an officer. And now we have an allegation of an attempt to disarm a police officer in the confined setting while within the jail. There are statements attributed to the defendant in this complaint that says, and I quote, "I'm going to bail out on Monday morning, no matter the amount of these new charges, and kill myself. I don't care if I have to spend every dime I own to bail out so I can kill myself. I don't care if it's $10,000 bail, $30,000 bail, or $50,000 bail, I'm going to kill myself, end quote. And then there are some statements acknowledging that it was a serious attempt to gain access to a firearm, again, within the confined setting. My goal in setting cash bail in this case is not to punish Mr. Misener. That's not really the point of an initial appearance or a bail hearing. It's not to pile bail money on the other bail money or to criminalize mental health. It is to ensure the safety of the community, including Mr. Misener. He's shown a demonstrated ability to post substantial amounts of bail in the past, incredibly high amounts of bail. There's incredibly high risk here. At some level, if I have to make a decision between setting an amount of bail that is beyond Mr. Misener's reach and doing that in a way that preserves his life and that of other people, I'm going to make that decision. And that's what I'm doing here today. So, and Act 3 was designed in part, I think, to have some ability to apply some form of preventative detention by way of cash bail. I don't know whether the number I'm setting today will achieve that goal or not. The statements attributed to Mr. Misener in the complaint and the actions in the past in terms of posting bail suggest that there's a high ability to post. He's telling me something different today. That could also be true. I don't know the answer to that, but I'm not setting bail on this at anything less than $100,000. I'll set that bail. I'll not set any specific conditions at this point. The defendant's entitled to a timely preliminary hearing. And we'll get that scheduled. Why don't we do it on August 14th at 3 o'clock? That's when the other hearings are scheduled on the defendant's other cases. I want to be clear to you, Mr. Misener. I'm not doing this because I dislike you or I'm upset.
Your Honor, I have $5,000 to my name. $100,000? Are you kidding?
Unfortunately, I'm not. I wish this wasn't the situation. I care too much about you not hurting yourself or hurting somebody else to tinker around.
That's what I received treatment in the hospital for, Your Honor.
All right, so you're going to have an opportunity to have bail reviewed at the preliminary hearing. We'll get that set. Good luck to you.
Go fuck yourself!
Next few minutes, wait a minute.